Good afternoon, everybody. It is Thanksgiving week, and I hope everyone is having a nice weekend. I do these weekly live streams on Sunday afternoon. I try to have it at the same time. It's usually at 3 o'clock, although last week I did the show from Philadelphia, and I ended up doing it later in the day because I was traveling. And today it's starting a little bit later than I anticipated, for which I apologize. But I wanted to talk about evidence. Evidence isn't really discussed in newspaper articles or social media. It's generally only examined by lawyers and judges. And the reason is when somebody is on trial, okay, in a court of law, not everything, not every bit of information comes in. And that may be surprising because you would think that when you have a trial or a court proceeding, that all the information come in and have the judge or jury decide after looking at all of the available evidence. But that actually is not the case. And I wanted to talk about how courts deal with information that wants to come in versus what happens outside of court, in the court of public opinion, which includes social media. So what am I getting at? I want to talk about 4 recent events, and there's many, many more, but they all pretty much are similar. One person is Mr. Roy Moore. Okay, you may or may not have heard of Mr. Roy Moore. He's an American politician and a former Alabama state judge. Mr. Moore is the Republican nominee in the 2017 special election to fill the U.S. Senate seat that was vacated by Jeff Sessions and currently held by Luther Strange. Why am I talking about Mr. Moore? Multiple women have come forward and alleged that Mr. Moore engaged in unwanted sexual advances or assaults. One woman claimed that this happened when she was 14. Mr. Moore denies the allegations. These are all facts. Okay, Mr. Al Franken. Al Franken is a U.S. Senator from Minnesota. He has been accused by Miss Leanne Tweeden of sexually assaulting her twice. A photo came out of Mr. Franken. You may have seen this photo. And it created an uproar. And that case, with the allegations and the counter explanations, have all been happening on social media as well. The third person I'd like to talk about is Mr. Stephen Battelle. For those of you who may not be aware, Mr. Battelle is the fairly recently appointed or elected chair of the Florida Democratic Party. He resigned on November 17th, just a few days ago, as a result of an article that came out where 6 women complained of Mr. Battelle's demeaning behavior. He has been accused of being creepy. And the fourth person I'd like to mention is a journalist, actually. His name is Mr. Jordan Sheridan. Jordan Sheridan is a journalist with the Young Turks Network. He formerly worked at Fox News, and recent allegations have come out where former colleagues and employees have accused Mr. Sheridan of harassing and sexually assaulting them. He is currently on indefinite leave from the Young Turks, I believe. Mr. Sheraton has denied the accusations, and I believe, well, he did write an article where he stated that he believed that the sexual contact was consensual. Four cases. Now I'm going to talk about the federal rules of evidence. Okay. The federal rules of evidence are rules that govern all federal courts in how information that is proffered as evidence gets admitted. I put a link onto my blog post. The federal rules of evidence are readily available for your examination. But the first rule I wanted to talk about is Rule 401, which is the relevance requirement. Okay. What this means is, if any of these gentlemen, Roy Moore, Al Franken, Stephen Patel, Jordan Sheraton, if the allegations that are surrounding each of these people, if they were to be tried in a court of law, not everything about the situation, the person accused of wrongdoing or the accusers come in. That information must be relevant. So one example where a relevancy fight might happen is for Mr. Roy Moore. Mr. Roy Moore is a very conservative-leaning politician. If you have a jury that is full of liberal-leaning jurors, the fact that Mr. Moore is ultra-conservative, as some people might say, is not really relevant to the fact that a group of women are alleging that he engaged in sexual misconduct. Now, in fights over relevance, because obviously one side may argue that that information can be relevant and the defense may argue that it's not relevant at all, those arguments are determined by a judge. So the judge will determine whether or not that piece of information comes in or not, whether it passes the relevancy bar. But as you can see already in a trial, a lot of information will never get to the jurors because it's just not relevant to the accusations that the accused is standing charged of. And that's one example. Here's another question of relevancy. Senator Al Franken. He used to be a comedian. Is that relevant to the photograph? Is the fact that he used to be a comedian and would get people to laugh by doing funny or outrageous things, is that relevant to his defense in what he was doing to this sleeping woman here? As you can see, that could be a fight, because Mr. Franken's lawyer may argue that it is relevant because it explains that he meant no harm. He was just trying to be funny, and he had no intention of going beyond getting a few yucks. But the prosecution may argue that it's not really relevant at all what he did for a living before he became a senator. What he's doing here is all that matters. So issues of relevance are not as clear-cut as they always can be. But that is one threshold that information needs to meet, that evidence needs to meet before it gets admitted into court. I'm sure anybody who went to law school remembers the rules against hearsay. Okay, hearsay is an interesting concept because outside of court, people love hearsay. It's true. Hearsay is nothing more than I heard it. I heard somebody tell me. Okay. Gossip is often hearsay. Whisper campaigns are often hearsay. Water cooler talks at work are often hearsay. You get a lot of good information from hearsay in the real world, but in court, hearsay is not allowed. Okay. There are rules as to why it is, but the general principle is that we just don't want easily corruptible information coming into court and polluting the process, because hearsay is, I'll give you an example of in Mr. Patel's case. Okay. In looking at Stephen Patel's case, in the article, there were women who said, I was told that young women should stay away from Mr. Patel. Told by whom? This is hearsay. What does that even mean? Now, in real life, I'm not telling you to not listen to that and make your decisions however you deem fit, but in a court of law, you just can't have a bunch of people take the witness stand and say, well, so-and-so told me you should stay away from Mr. Patel. Okay, that's hearsay. And there has to be something more than that. There has to be something more to allow what you have heard somebody else tell you to be admissible in court. There are exceptions to hearsay, which I won't go into, but I did upload an article put out by the American Bar Association, and it gives a little bit of discussion about hearsay and all these rules of evidence that I'm talking about, including the exceptions to hearsay. It's very complicated. It's a very well-developed system for evidence. You exclude hearsay, but there are exceptions where hearsay can be allowed. And then you have authentication. What is authentication? Authentication is you have, for example, a document. What is it? Where did it come from? Has it been doctored with? To go back to this photograph, okay, me showing you this photograph, it hasn't been authenticated. In order for this photograph to go to a jury, to prevent people from drawing all types of strange conclusions, you have to authenticate it. Who took it? And you have to have that person who took the photograph give evidence as to when and where they took it, right? There are exceptions to authentication, such as business documents, but you cannot just have random documents just come into court. But in social media, that's exactly what happens. Just stuff just shows up, right? You see emails, you see memes, you see all these documents, you don't know if they've been doctored with, they're not authenticated. So they can very well be highly misleading. The other federal rule of evidence I'd like to talk about is the federal rule that says that even if evidence is relevant, it shall not be admitted because it is prejudicial. And this is where many court fights happen. One side wants to bring in evidence. The other side says it's overly prejudicial. It's relevant, but it's just too prejudicial or duplicative. And I'll give you an example where in the case of Mr. Al Franken, remember this photo? What if I told you that this young lady who's sleeping at one point used to be a lingerie model, and I wanted to introduce in court photographs from her modeling days where she's wearing underwear or a string bikini or what have you? First of all, is that relevant? Now, I've already seen on social media that some people think that's relevant and some people think that's not relevant. And assuming it is even relevant to the accusation against Mr. Franken, the next question is, even if it was minimally relevant, is it not overly prejudicial? In other words, that type of evidence can be unnecessarily prejudicial to the jury, so that when you look at a photograph like that, you just don't want people to say, oh, well, I'm just going to believe Mr. Franken because she modeled in underwear 10 years ago or what have you, right? So that's, as you can see, that's where a lot of fights happen in court. When you see a court procedure and you see lawyers get up and go next to the judge and they're having a sidebar and whispering, that's usually what they're fighting about. They're fighting about some procedural rule or whether some piece of evidence should be admitted or not. And so for this week's Cranky Lawyer Legal Livestream, I urge everyone, as you consume all this information that's coming out on social media, to maybe take a look at the federal rules of evidence and see how an entire structure has developed to train professionals in figuring out and sifting through all the mountain of evidence that may come out in a case. I don't think you have to be a lawyer to read the rules of evidence, but I think it would help. Everyone to just have a basic training in how to consume evidence. If you have any questions, I'll be happy to take questions now. Okay, Mr. Phelps. Well, Mr. Phelps is talking about falsified evidence. Okay, so that's a good question. In social media, evidence can be fabricated. You don't know where a photograph came from. People could have photoshopped things. You just don't know. In court, because both sides have supposedly have lawyers, that information should come out. Okay, so if one side tries to submit doctored evidence, the lawyer for the other side would be able to find that out and tell the judge that's doctored evidence. They should be punished. Or if the document itself may not be doctored, but it's of questionable origin, at least have that also come out, right? So the fact that both sides are adversarial, some claim, is a good vehicle for having the truth come out. If both sides are truly adversarial, then the truth eventually will come out. Anybody else has any comments? I'll be happy to address them. I hope this has been, at the very least, somewhat interesting. And I have to say that I'm a little bit dismayed that in all of these cases, things are just sort of happening in social media, and then there are accusations and denials and counter accusations and counter explanations. And I don't necessarily know if the way things are going, it's fair to either the people who are making the accusations and the people who are subject to these accusations, because things stay in limbo. And I don't know if it's necessarily fair to anybody involved just to have accusations just hang in the air in social media. So I am hopeful that we can come to some sort of more rigorous conclusion when these allegations come out. Thank you very much for watching. If you'd like to support me in my weekly Cranky Lawyer live streams, please feel free to become a sponsor at patreon.com/Elizabeth Lee Beck. And I will continue doing these. And please also feel free to submit topics you'd like to be covered, and I'd be happy to queue them up and go over them on these live streams. Thank you for watching. Have a great Thanksgiving week, everyone. Bye-bye.